Court is ready to hear argument in 19-959 in the interest of G.X.H. Jr. and B.X.H. from Harris County and the 14th Court of Appeals District.
May it please the court, Ms. Hesham and Mr. Cooper will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal. Ms. Hesham will open with the first 10 minutes and will present the rebuttal.
May it please the court. My name is Sandra Hesham. I represent the Department of Family and Protective Services. This case concerns 263401 of the Family Code. It's a provision that was first enacted in 1997 to prevent legal limbo for children in child protection cases. Interpretation of this provision has never been easy, and that's well illustrated by this court's 2009 5-4 decision. However, new language in 2017, as interpreted by the court below in this case, shows that we have an even more difficult problem because it creates a nonsensical procedure. Namely, the court below has interpreted this procedure to not only unravel permanency for two small children who needed protection without consideration of the merits, but undoubtedly has created a process that will do so for countless other children in similar circumstances, contrary to the very purposes of this section.
Ms. Hesham, why would that be the case? Can't CPS just file a new suit?
Well, first of all, in 2009, this court made it clear in Justice Heck's dissent that the idea of refiling wasn't even something that was addressed by this court. And we don't know now, since it's a jurisdictional scheme, if refiling would be appropriate. Because if you're saying that there's no jurisdiction for the case, what does that mean? And I think that is something this court has to decide. What does that mean, jurisdiction in that provision? Then also, if you were to interpret this section to allow refiling, then it's going to create exactly the problem that the legislature intended to dissipate, which was delaying these cases, because you would have to start the process all over again. There are three reasons why the 263401, as interpreted by the court below, has become a nonsensical procedure. First of all, it's eviscerating permanency achieved on the merits on a technical error without any process for correction by anyone, even a judge who might not know an error occurred.
So, Ms. Hesham, if this isn't jurisdictional, then, and let's say a court, say if we didn't have the issue here of the paternity suit, and there's a situation, which of course we have to think about, where clearly the court disregarded the time limit in terms of beginning the trial, what would be the remedy, the ramification of that?
Well, okay. I'm trying to understand the scenario. You're saying that if it wasn't written the way it currently is written?
No, not written. If it involved different facts, where paternity, the filing of the paternity wasn't an issue, or whatever. If it was just clear that the trial court did not commence the trial within the required time, but this is not a jurisdictional statute, then what would the remedy be? Okay.
So if the time under the prior scheme, it was not a jurisdictional provision. And
are you acquiescing that the insertion of the word jurisdiction in the amended statute now means that this is a matter of subject matter jurisdiction?
I don't really know. I don't really know the answer to that question. Obviously, the legislature added the word jurisdiction. So it has some meaning. Now, does it mean jurisdiction from the standpoint of personal jurisdiction? Does it mean jurisdiction from the standpoint of subject matter jurisdiction? Obviously, the problem with subject matter jurisdiction is that it can be brought up at any time. That is our concern. Obviously, this was brought up for the first time on appeal. Normally, you can't bring error on for the first time on appeal. So they did bring it here for the first time on appeal. So if it's not subject matter jurisdiction, it's waived, and we shouldn't even be having this conversation. But if it is jurisdictional, as it's suggesting, then we have some major problems, which I think have to be addressed. The only other way I can think of it as being what they would mean by jurisdiction is jurisdiction for that day. In other words, that day, the court doesn't have jurisdiction. Now that if it was limited to just that day, then the next day, if the court exercised jurisdiction, all bets are off. It's fine. But I think it's the legislature has put the court in a difficult circumstance in trying to determine what that meaning means in light of the many difficult issues that can occur.
It says, doesn't it say jurisdiction over the suit filed by the department is terminated? I mean, that seems pretty clear. Now, your argument is that leads to consequences, but isn't it the legislature's job to decide whether it desires the consequences of what it says?
The legislature does have the prerogative to decide however they want to word something, but they still can't word a statute in a way that it renders an unjust and unreasonable result, that renders unconstitutional constructions, that avoids the very intent that the legislature was meaning in that section. In this case, the section was written in order to avoid legal limbo for children in child protection cases by allowing this scheme to operate in the manner the court below has provided. Then you have a situation where the child is essentially in legal limbo indefinitely, because you can have errors happen that no one finds out till much later. In this case, we didn't find out about the court not signing the extension order until the appeal. So what about 10 years from now, somebody's had an adoption, same thing happens, and you're going to say, well, there was no jurisdiction, so that termination is undone, and so is the adoption? That would make no sense. The legislature could not have intended that result. And we have to construe statutes in a way that it's constitutional. We're also supposed to, at least under the Code Construction Act, it does provide that we're supposed to look for a just and reasonable result, not an unjust result. And we're supposed to find one that tries to meet the intent of the legislature, which in this case clearly was to not expose children to legal limbo, which this scheme does. In fact, the way that the appellate court has interpreted it does expose these children to legal limbo. It's something that we should never permit in a child protection case. And certainly this court, in deciding the jurisprudence of this state in this very important area of law, should do everything it can to construe this statute so that the rights of children to be protected are not eviscerated in a scheme that was clearly not written for that purpose.
Ms. Hatcham, go ahead, Justice.
Well, it seems like the Court of Appeals interpretation about the commencement of trial is at issue. So mindful that the legislature said that the statute's jurisdictional, how can we interpret commencement of trial and the ordinary presumption that a trial judge has subject matter jurisdiction in a way that coheres with the legislative scheme, but also affords everyone the opportunity to determine these rights?
Your Honor, I'm glad you asked that question. I do think there is a way to interpret the statute so that it is not causing the problems that the lower court's interpretation caused. First, the way we would have to do that is construe it in the manner that the Code Construction Act has required us to, which is to look at the plain meaning. And the plain meaning of commenced means you start. And what does the meaning of trial on the merits on the department suit mean? Well, first of all, it's only a trial on the department suit. It's referring to that. And so when it says commencement on the department suit, it's meaning the claims that are in that suit. And then we have to look to the rules of procedure, because the Code Construction Act would have us look at laws that would be similar in the process. And if you look at the rules of procedure, the rules of procedure allow a trial judge to start a case on any issue, and certainly a pivotal issue that's important to the case, if that would be in the interest of justice.
But Ms. Hashem, in this case, wasn't the point of the paternity suit really a technical issue? Because the point of the suit was to terminate parental rights, not to declare parental rights. And so the declaration of the parental rights was simply done so that the gist of what was going on could be done, that is to undo those parental rights, right?
Actually, it's not technical. It was pivotal to this case to know who was the father, to terminate the correct father's rights. We don't want to keep a case going with a bunch of men that have been named as fathers and make them stay in the suit when in fact, it's only one guy that's the father, and we're only seeking termination as to his rights. Certainly that's not technical. That's the child's parent. And that's the parent that we need to have adjudication in order to protect that child's right. So I think that that is a pivotal issue. And in addition, I'd like to mention that, you know, when you consider the phrase commence trial on the merits, you also have to consider that the family code has other processes that lets a court commence trial in a way that wouldn't do it in the way that you would normally commence trial. For example, 153.0071 of the Family Code allows a court to accept a mediated settlement agreement to resolve all issues in the case. Well, now, of course, if a court had a hearing on a mediated settlement agreement, it would not be commencing trial in the typical way that you would start trial. And so is it going to be the position that if we don't commence trial in a way that has contested rights and right to jury trial and all kinds of issues that you would normally have in your traditional trial where it's contested, that it's not commencing trial on the merits?
Ms. Hatchett, your time has expired.
Oh, I apologize.
You'll have time on rebuttal. Mr. Cooper, we'll hear from you.
Your Honor, may it please the court. I'm sorry, I was having a problem with my mute button there. May it please the court. My name is James Mark Cooper, and I am the attorney for the children in this case. In the cases that we handle down at the trial level, we have children that come into care for all manner of abuse, sexual abuse, physical abuse, neglect. They come in, they have bruising to their eyes and their ears. They have broken bones, they have broken ribs, they have lacerations to the inside of their throat. And sometimes when this occurs to them when they're as young as 2 months old. So these issues are very, very important. When children are beaten by parents, that's not a situation that they should ever have to be placed back in.
Mr. Cooper, we understand the seriousness of these cases, definitely. But the legislature has chosen to insert the word jurisdiction. And in light of some of the serious repercussions, let's say if a final order terminating parental rights were entered in one of these cases and the child was adopted by another party, if in fact this statute renders a decision that was made outside of the timeline void, then the parents could file a collateral suit, could collaterally attack that judgment, could claim that it was void and demand that their child be returned immediately over the rights of the adoptive parents. So what is your response to that argument in light of the insertion of the word jurisdiction in the amended statute?
So, Your Honor, I believe that it is an issue, that it is jurisdictional, and I believe that it is, because clearly that's what the statute says.
Well, but there's many types of jurisdiction. Subject matter jurisdiction is the type of jurisdiction that would render the devastating results that I previously described. And so is your response the same? So
it draws open the question of whether or not the department could refile, and furthermore, whether they could refile on the exact same set of facts or if they're going to need some additional facts, new facts pled in to begin a new case. I believe that's an open question, and I believe the court below here indicated that the department could refile. I would like to point out, though, that the resolution of this case, in my view, is whether or not the case started on time, because the trial court did in fact extend the case. They granted an extension order. It is in the docket sheet. That's my first point of error, is the docket sheet states that there was a motion for continuance, that the agency, the county attorney, myself, it's a serious injury case. There was an agreed continuance, and a new trial date was picked in October, and it states the extension granted to reach the trial date. So in my
Mr. Cooper, your position, okay, I'm sorry, go ahead.
In B.X.H, we said that you can't just enter an extension order, that you have to make specific findings to support the extension order. And there have been changes to the statute since then, but not to that particular provision. So why wouldn't B.X.H say that that extension order is not enough?
So, Your Honor, all I can say is that it's implied that the court made such findings. I didn't know that the statute required any particular form or written order of findings.
I don't think it requires a written order, but DFPS doesn't say that. It just says the court needs to make the findings, that not an extension is not enough. So it could be oral, I think, under DFPS. But is there any evidence that the court made oral findings on the required elements of the statute?
So, Your Honor, there was no record made. I can tell you that I was present, but I don't want to put myself in a position of testifying at this point. But I was present. I could tell you what was stated. I could tell you who was present in all their positions. But I feel that would place me in a conflictual situation.
Mr. Cooper, would the jurisdictional question come into play if the extension is granted and there's no objection to the lack of a written order, to the lack of findings, and there is a docket sheet entry but no hearing? Can we presume then that the trial court made the necessary findings to grant the extension?
I believe so, Your Honor. And further, subsequently, back in that October date, there was a permanency order that the judge signed, which gave a new dismissal date. And so that's further evidence that the court made the findings and granted the extension.
Any other questions? Justice Bland? Thank you, Mr. Cooper. We'll hear from the respondents.
May it please the court, Mr. Connolly and Ms. Williams will present argument for respondents. Mr. Connolly will open with the first 10 minutes.
Good morning. May it please the court. The department urges that this is some sort of nonsensical procedure, and then it's actually a more liberal procedure than previously existed in 2009. The department had 5 choices to it. They could commence trial at the time it was actually set for trial, and they could finish the trial. They could commence trial and request a recess. They did ask for continuance, and they did ask for an extension. So as long as you get the finding from the trial court of extraordinary circumstances, then you can extend it for up to another 6 months. There's no indication anywhere. There's no record from the trial court. There's no verbal rendition. There's no written.
Not only, why isn't this a situation in which we would imply the findings necessary to support the trial court's judgment, and in this case, the trial court's ruling that there was a continuance?
Well, I mean, if you follow your own precedent of the court that says the court can't just make a finding or can't just enter an order, I don't know how you imply something happened when you have no record in the trial court of record that it actually did happen. You would have to just assume that the trial court meant something or did something. The docket sheet entry makes no finding at all. So what you have is no evidence anywhere the judge refused to sign an order. There's no evidence that the court was even presented the order. You can't just file something and expect the judge to know that it's there. You have to actually ask the judge to sign the order. There's no evidence of any motion to enter, motion to compel the judge to sign it within the time frame. There is even a provision in the law that allows for mandamus if the court doesn't do what it's supposed to do.
Mr.
no
Connolly, is it your position that not just whether the continuance is granted or denied is potentially a jurisdictional question, but also whether the findings necessary, the lack of a finding could mean the trial court loses jurisdiction, the lack of a written order can mean the trial court loses jurisdiction? Are you saying each one of these elements to a proper motion for continuance is also potentially jurisdictional?
I'm not sure I'm following your question exactly.
Well, there was no objection raised in the trial court to the lack of findings to support the continuance, to the commemoration of it in a docket sheet as opposed to a written order, although the family code allows, I think, docket sheet entries. So are those things that there were to which there was no complaint or objection raised in the trial court to alert the trial court, are those also jurisdictional requirements?
Well, no, but I think if you're asserting that a statute and a statutory scheme is somehow unconstitutional or nonsensical, you have to look at how it operates in practice. And how it operates in practice is just those things that I outlined. You have the responsibility, if you know when the dismissal date is, to make sure that the judge does something to preserve the court's jurisdiction, or you have to try your case. And the department not only didn't try their case, they asked the court for permission to not try the case. Case was set for trial, so it's the department itself that asked to not try the case. So I think you have to go through a process of making sure that the court's jurisdiction is preserved. Do each of those elements, are each of those required in some sort of jurisdictional analysis? No, but I think if you look at the procedure involved in the case, you would have to say that nobody did anything in the 25 days between the docket sheet rendition and the time of the dismissal date to preserve the court's jurisdiction. And I think it's an essential part of the analysis.
So Mr. Connolly, are you suggesting that in a case where, let's say, the attorneys, and I'm not talking about this case, let's say another case, where the attorneys were negligent, the trial judge was negligent, they did not try the lawsuit in the appropriate amount of time, but the child certainly didn't do anything towards making that happen. A termination order is entered, adoptive parents adopt, and 5 years later, the parents can come in and seek a declaration that that order is void and take that child from the adoptive parents. Is that what you're suggesting?
What I'm suggesting is that the legislature has the power to create timelines, and nobody really disputes that.
Does the legislature have the power to do what I just set out?
Well, the legislature is not doing that to the parties. What the legislature is doing is putting a timeline on the lawsuit and establishing fairly easy procedures to comply with. If the parties don't comply with those procedures, the same way, if I didn't file a timely notice of appeal, you don't have jurisdiction. What the statute says is the court loses jurisdiction. And if the court loses jurisdiction over that suit, then any order that comes out of that suit after the court loses jurisdiction is void. I think the Court of Appeals is correct on that. Are there possible consequences in certain scenarios that would dramatically impact it? Yes. Are there possible scenarios? But we don't decide constitutional issues on hypotheticals. I understand the concern, and I understand that they would go back to the trial court. But you would also have to understand that the grandmother intervened in this suit, that if this case went back to the Court of Appeals for if you found in favor of the department and it went back to the Court of Appeals, they would have to do their sufficiency review. If you found in favor of what the Court of Appeals held and affirmed the judgment, then the department would refile. Everybody assumes the department would refile, whether they have to refile under new facts. But I think that in your scenario, Justice Lerman, there are intervening facts and factors that would be litigated in the trial court. And it wouldn't necessarily mean that the parents have an automatic right for a return of that child.
Are you basically saying that the filing of a new suit by the department would resolve the matter?
I think the filing of a new suit by the department is likely. Would it resolve the matter? I can't forecast that, but the likelihood is that there would be intervening circumstances. The child's placed with the grandparents, so there are intervening circumstances. There are factual considerations that would have to be made. Whether the result would be identical, it's unknown. So I don't think it's nonsensical, and I don't think the whole idea of a paternity suit or paternity determination ancillary to an adjudication is the commencement of trial. Because if it is the commencement of trial, then by their definitions cited in their briefs, what we would end up with is a trial that begins at the adversary hearing. Destroys the purpose of the statute altogether, because any adjudication on any ancillary issue then becomes the commencement of trial. And we don't have any due process for the parents. It actually flips any due process considerations completely, because what it does is condones a trial with no notice of trial on the merits at all. And we know that the department didn't want to go to trial because they didn't want to go to trial later. They still didn't have the records that they said that they needed when they gave their first trial setting notice. So it gets rid of discovery, it gets rid of due process, it gets rid of everything, and it leaves the cases open indefinitely. I think the Court of Appeals was spot on when it says this is the very practice the legislature tried to address by making this statute the way they did.
Mr. Connolly, what is the children's conservancy custodial status now post the Court of Appeals decision here?
Well, it's interesting. The trial court did not honor the Court of Appeals, and so it's conducting hearings as if the department still has conservatorship. The parents aren't getting notice. The parents have no representation in the trial court. The kids are placed with the grandmother, and it's going unabated as if nothing happened in the Court of Appeals to set aside.
So if we affirm and issue a final mandate and you're in favor of the position that you're representing here, then what will become of their status?
I would assume, I can't say for certain, but I would assume the fifth option, which the department had at the time the Court of Appeals opinion came out, which was to refile then and to assert jurisdiction, that they would refile. They would refile and ask the court for conservatorship. I would assume they would ask for the court for termination as well. The court would enter some temporary orders based upon whatever evidence was adduced, and I would assume that that those orders would be appropriate and protect the best interest of the child.
Any other questions? Thank you, Mr. Connolly. Ms. Williams, we'll hear from you.
Yes, if it pleases the court, I would like to begin. My name is Pamela Williams, and I represent the mother in this case. And we think that this case is pretty simple as it relates to the legislature's intent, which was to give parents due process rights as well, to not have their children in limbo indefinitely by establishing a deadline upon which, had that deadline not been appropriately reached, that the case would be dismissed. And this case is very interesting because never would you hear of a deadline that the parties did not know that the judge didn't have extend the deadline. We believe that the parties know that the judge didn't extend the deadline, because I don't agree, with my co-counsel. I don't believe that a motion for retention was ever heard. I believe that the continuance was by agreement, which the courts of appeals, as well as this court, has said that you cannot extend these deadlines by agreement. There was no finding of any extenuating circumstances. And this is what the courts of appeals and I believe the legislatures, in saying we've got to give some balance, that these trial courts don't continue to allow the heavy hand of DFPS to come up with excuses, which is what they did in this case. There was no notice of any type of hearing. My client didn't have a lawyer there, but there was no notice. There was not a 3-day notice of a motion for continuance or a motion for retention. And we didn't even, the DFPS just, to me, it's just mind-boggling that they did not even argue the fact that they had filed an extension or that an extension had been granted in the 14th Court of Appeals. They did not argue that. They waived that because they knew that that was not valid, and they began to talk about permanency hearings that may have reconferred jurisdiction after they admitted that they lost it because they did not properly get this deadline extended. And it is not difficult for either side, be it DFPS representing the state as they do, to make sure that, quote unquote, the judge does render the decisions that will make them win their cases. They're very good at that, but sometimes I believe there are times when, as in this case, it simply was not done. And this is a situation where they, the penalty for the failure to actually file a motion and a proper motion and get an extension and have extraordinary circumstances, as well as set some dismissal deadline, which none of that was done in this case. It should, it must have the results that the legislature was trying to get some balance for these parents, because oftentimes in the previous statute, there would be this issue about parents not knowing that there was a dismissal deadline that had been waived, and therefore they were not able to even avail themselves of their rights because they had not filed these motions. And I believe that the legislature, in giving some of these poor parents who are, oftentimes indigent, fighting for their most important liberty interests, the balance of saying these professionals are in this court, they must make the required findings, they must follow the law, just as if a parent in the past had not filed a notice of appeal with the specific allegations of what they were appealing, they could not appeal these termination proceedings. So in this case, there was no finding of extraordinary circumstance. There was no, I don't believe there was a hearing. I believe that a continuance was gotten together, with the parties that were present, and they just entered a docket entry. Nothing in this docket entry. Yes, ma'am.
Say we agree with you that it was error to allow a continuance by agreement, to do it without a written motion, to do it, without a record. Are those errors, though, do they rise to a jurisdictional level and such that when the trial court commits the error, it deprives the trial court of jurisdiction over the case?
Well, according to the statute, because the extension in the case law, because the extension was not granted prior to the expiration of the date, the dismissal date, therefore you cannot extend that dismissal deadline after it has passed. And that is what the Court of Appeals pretty much in a straightforward manner rendered an opinion that was in line with that. And I believe that there have been times in the 14th Court of Appeals where the issue of whether or not a docket entry somehow, would be in order. But in this instance, that wasn't even brought before the Court of Appeals. And I think the Court of Appeals is 14th Court of Appeals, they do want the specific findings, the extraordinary circumstances, the dismissal deadline. That was not done in this case. This simply says motion for continuance granted. It doesn't even mention anything about a motion to retain. And then there wasn't even the state.
Ms. Williams,
ma'am.
Williams.
Yes, ma'am.
Let's say that we do agree with you and that the appropriate remedy is to dismiss the lawsuit because that's what the statute says. But in the language of the statute does not use the word subject matter jurisdiction. It simply uses the word jurisdiction. And so would you agree that if we were not to determine that this was a matter of subject matter jurisdiction, but that dismissal was appropriate, that would be sufficient to protect your client?
Well, I'm understanding that if the case were to be refiled by the department and that there would be additional proceedings, potentially because the department does have the right to refile, that they're not barred by any kind of statute of limitations, as what happens a lot of times when deadlines are missed. So I do believe their right to refile is, something that it looks like the law does support. But the deadline that was missed, that actually, the deadline that was missed resulted in that dismissal per the legislative's intention. And paternity finding, as the court has said, that has nothing to do, those are two different types of proceedings. And my client at the very beginning of the case, there was no commencement of trial, which is what the 263 statute requires, that trial commence. So the paternity was not a commencement of trial. And that would be highly—
Ms. Williams, isn't determination of paternity at the outset necessary so that the trial court can, at least on a temporary basis, put in place a parenting plan and allow the now adjudicated father an opportunity to demonstrate that termination would not be in the children's best interests?
Well, the commencement of trial, I think on the merits is what the statute talks about. So that would not be a trial on the merits, as well as the fact that, that it's a jury requirement under a termination hearing versus a paternity where that's just an adjudication. So it would not be a commencement of trial on the merits. And there's nothing that my client or we find unconstitutional about this statute. The hypotheticals that were raised do not suggest that there's any due process violation, no other constitutional violation, no equal protection violation. If anything, the statute is helping to protect parents get some type of justice and balance by making sure those who are, holding their children in order to supposedly protect at that time, that they follow a set of rules so the parents can have their privacy interest protected as well. So, we believe that the 14th Court of Appeals was absolutely right. And the motion to retain that the state has attached as an attachment, it wasn't even in the Court of Appeals, because we believe they know that there was no hearing, but there was just an agreement as what the docket order says.
Any other questions? Thank you, Ms. Williams.
Thank you.
Ms. Hashem, I believe you have 5 minutes for rebuttal.
Okay, am I unmuted? Okay, there. All right, okay, so there's something I wanted to mention to you that I hadn't mentioned in my brief. I started a review of all the other states in this nation that have child protection statutes. I did not find one that dismisses the entire case if you don't meet a technical deadline and with no plenary power, et cetera. So I just wanted to mention that. Another thing I wanted to mention was that my opponent says that it was the department's fault in not getting an extension order, that they needed to make sure the court did the thing that extended the case. Well, let me just tell you, in this process, we did everything we could do. We filed a motion asking for extension. We filed a proposed order for the extension. We had a hearing. The court made a docket entry making us believe the court signed an order. Now, the fact that we didn't see the court, we see the court signing things, but we rarely see the court actually signing the order because the court does other cases and things. So,
Ms. Hashem, let me ask you, please, in response to the opposing side saying that there are no constitutional issues at stake because the statute is meant to protect the constitutional rights of the parents, what is your response to that in light of the fact that the real constitutional issues here deal with the child? And obviously, what is your response to that?
Well, yes, one of the rules of statutory construction is that you consider the public interest to prevail over the private interest. And there's a very strong public interest in children that are in situations of abuse and neglect being protected by a scheme that the legislature agreed should be part of our law, and it has been for many years, and it's been needed. We've got children that require protection. So the interest of the child is also a very important point I wanted to make. That child's interest, when y'all, when I've read different opinions y'all have written on different issues and concerning due process, usually it focuses on a process that wasn't given to the parent. Like, for example, JOA, which is at 283 Southwest 3rd, 336. In that case, y'all considered 263405I, which kept a parent from being able to bring an appeal because they didn't file a timely, and another technical point, statement of appellate points. Y'all found that found that unconstitutional to preclude a parent from bringing an ineffective assistance claim just because they had no way of fixing it. That's really the situation here. There's no way that we can force a judge to sign the order right then. And the judge can even make a mistake and we can't correct it. Normally, when you have something overruled by operational law, like a new trial, when it's overruled by operational law, you have 30 days plenary power, a process, a meaningful process, in order to say, Judge, you made a mistake, fix it. And so we don't waste judicial time and energies on something like this. But that process is not here. We don't have a plenary power. That's what makes this so nonsensical. It makes no sense to give a power to a judge to do the thing that we can't force by any means. And when he doesn't do it on time, and we don't know he didn't do it until the next day, we can't complain or do anything to fix that. We can't even fix it on appeal because there's no jurisdiction. So this,
I think there's been some suggestion that we might consider the requirement of findings not jurisdictional. But if that's the case, would that need to be something that the department would need to raise before the Court of Appeals rather than waiting until a motion for rehearing?
Well, I don't think so. Actually, the way the statute is written is it says the court in subpart B, it says, if the court makes these findings of extraordinary circumstances, then the court's jurisdiction extends up to 180 days. And it can,
So you think the requirement of findings is jurisdictional?
I don't think it's, I think it is the thing that allows this extension. But what is the thing that actually is jurisdictional may be different, because what subpart A says, unless the court has commenced trial or granted an extension. That's what subpart A says. So the key is, has the court granted an extension? We have a docket entry that says the court granted an extension. And then we must imply the court did all things to grant that extension, because subpart B tells you how a court grants an extension. Subpart B says the way the court grants an extension is by making findings. It doesn't say they have to be written. It doesn't say it has to be on the record. It doesn't say anything. So essentially, it made it a very easy process for the court to retain the case. But the court has to grant an extension by doing something. So basically the court is—
Your time has expired. I think we have your position. Thank you.
May I just make a conclusory statement?
Yes.
No law of this state should be interpreted to eviscerate the meaningful rights and process due to children, and certainly not in the context of this state's jurisprudence on child protection law. It's therefore respectfully requested that this court correct the interpretation of the court below and remand it to permit conclusion of the appellate process so we can have permanency and protection for these children.
Thank you.
Chief, I have another question. I'm sorry.
Sure.
Counsel, I'm going to switch gears on you, and I understand you may not know the answer to this, and you may want to follow up. Article 4, Section 22 of the Constitution says that the Attorney General shall represent the state in all suits and pleas in the Supreme Court in which the state may be a party. The DFPS is frequently a litigant in this court. They're represented either by a county level counsel like yourself, or sometimes by DFPS counsel in Austin. I don't know that I've ever seen the Attorney General involved. And I just wonder why that is, given what the Constitution says about the Attorney General's obligation to represent the state, and whether there's some sort of a delegation or there's a statute, or what the department's position is on why the Attorney General, or maybe what the Attorney General's position is on why it's not representing the department. You may know the answer, or you may want to get back to us.
Well, I do know the answer, at least in my own practice, Your Honor, because this has been the practice for many years. I did ask that question soon on when I was asked to be the appellate attorney for the department in our office. And I've spoken with our regional department attorneys, et cetera, about this issue. And it really, the answer I've been given is that the Attorney General just hasn't, they either don't have the staff or the desire to do it. And so essentially they are delegating it to us to permit us to do it. So yes, I agree that they're delegating. As you might notice, I did give them notice in this appeal of this appeal, so they could have proceeded in this had they wanted to.
Any other questions? Thank you, Ms. Hatcham. The case is submitted, and the court will take a brief recess.
Just remind everyone we're still live.